Hello, this is Dane Ciolino, and welcome to Lawyering 2's lecture on Introduction to Oral Argument. As we've discussed over and over again this semester, this course is about advocacy and persuasion. While last semester in Lawyering 1, you spent time learning the basics of legal research and writing, this semester is all about persuading not a fact finder, but a judge or judges. When you take the trial advocacy course in the second or third year, that'll be about persuading fact finders at trial. What we're going to do in this lecture is talk a little bit about oral advocacy. Of course, up until this point, we've done some oral exercises in the class, but the big oral exercise that is coming up, the big interim exercise, gives you the opportunity for an extended legal introduction, analysis of your client's case, and an attempt to persuade a hypothetical three-judge panel to rule in your favor on an appeal. And of course, at the end of the semester, you're going to do the huge oral assignment, which is your opportunity to do the same in a more formal moot court setting. Okay, so first of all, what are some of the goals? What should your strategy be? And how should you prepare for your first oral argument? Well, the goal one, and this is so important, is do no harm. Most judges are persuaded by the briefs. Your brief presumably has been filed. It's a good brief. You've edited it. You've made it persuasive. You've put your best feet forward in that brief. So you don't want to lose any gains you've made through written advocacy while you're at your oral argument. So that's goal one, do no harm. But you also want to use this oral argument as an opportunity to focus on the facts, the rules, the policies that are most favorable to you. Remember, when you stand up, you get to decide, at least in the first instance, what you're going to talk about. Don't let your opponent define for you how you're going to approach this oral argument. Now, I know the judges are going to start asking questions, and as one boxer famously said, everyone has a plan until they get punched in the face. But you need to focus on what you believe will make your case a winner, not responding to everything that has come out of your opponent's mouth or has been set forth in their brief. You've got to directly address the questions for the judges. And I mean, when the judge asks a question, you look the judge in the eye and you answer the question. Don't evade. That makes it look like your argument is weak. So you've got to directly answer questions. And you've got to motivate the court in a way that an impersonal brief cannot. You've got to draw on your ethos, your personal advocacy, to show that you know the case, that you are credible and believable, and that your side is the right one. And we do that with a lot of personal interaction. Now, sometimes oral arguments are done by Zoom in this post-COVID world. So you need to think about how you can do those things and bring those oral advocacy skills to the colder, more sterile setting of the video argument. But again, you still have that opportunity to motivate the court in a way that you can't do it in writing. And one last don't. We started with a don't, so let's end with a don't. This isn't about rehashing your brief. They've read your briefs, probably. Not always, but probably. So if you stand up there and rehash, or worse yet, read your brief, you're wasting your time and it's going to come off terribly. Okay, so how do you strategically order your brief? Organize your argument. Well, you organize your argument by issues and principles, not by case. You don't say, well, I'm going to start by talking about the alpha versus beta case, and then I'm going to move on to the sigma versus theta case. No. You're up there. You have structured your brief with hierarchically and categorically using Roman numeral 1 and big A and outline format. You need to do the same sort of thing in your oral argument. Now, you're not going to say, moving on to Roman numeral 2, Your Honors. You've done that in your brief, but you are going to take it principle by issue, argument by argument, principle, however you want to say it, categorically, not by authority. Prioritize those issues that are most favorable to you in your case. You get to choose, remember. Now, again, until you get punched in the face and those questions start, but you get to choose. So you pick the issues and the arguments that you think are most important for you to win the argument in the case, and start with those. Of course, you got to anticipate what the judges are going to ask, and you've got to be ready with answers. I sit there when I'm getting ready for an oral argument, and I look over all of the issues, and I say, if I was a judge, what would I ask about this? And the questions are going to come from what judges may not truly understand, and then the soft underbelly points that the judges want to poke you on and prod and probe to try to see if you've got good answers for the problems with your case. And during the argument, you need to concisely refer to the case law and support your key points. You've got to know the key cases inside and out. Now, you'd be surprised, sometimes judges have really read through the key cases. Sometimes they haven't, but you need to have them ready. You need to know basics, what happened in those cases, who the court was, what date they were decided, and what the holdings are. You don't have to recite complete citations. For God's sake, don't stand up there and say, yes, Your Honor, that's at 123 Southern 3rd, page 274. That looks a little annoying. You don't have to do that. You have to know the case, and you can look down in your notes for particular cites to particular pages if they're critical. Don't plod through the facts in some case cited in your brief or that you've just mentioned in oral argument. It may be important to mention them very briefly, but that's not what this case. You're arguing your case, not about some case that happened 10 years ago and it's now exists only in Southern 3rd. Okay, so to prepare your own oral argument, think about your ideal path. Like, if you can control this, how would it go? What would you discuss and when? And just assume that you're going to construct this oral argument with no questions. That is an important assumption, because you might just get what they call a cold bench and get no questions. And if you've only prepared 5 minutes worth of argument and you've got 20 minutes, now nobody gets mad if you sit down a little early, but if you sit down after 5 minutes, it looks like you've got nothing to say. You need to prepare, if you've got 20 minutes, a 20-minute oral argument, and you need to prepare for a 3-minute oral argument. So you've got to construct your ideal path, and then you might start by looking at the structure of your brief, obviously. And if you know that basic path, you can easily get back on track, get back on that path after you're being peppered with questions and taken over here and hither and yonder by the questions. Then once that path is set in your mind, you can always get back to it elegantly. And of course, you've got to consider what other paths this whole argument may take. And then be ready to just focus in on the must-win arguments and what facts are critical and how you're going to deal with the weaknesses with poise. You don't want to just go, oh my God, I was afraid you were going to bring that up. You should say, Your Honors, I'm glad you brought that up. That's the biggest problem with my case. But let me tell you why it should not dictate the result. No, again, that's a good way to handle a difficult question, a weakness with poise. You have got to know your record cold. If you want the court to view you as the expert, and remember, that's what ethos is all about, is showing that you know the facts, you know the law, and that you're not trying to deceive the court. You've got to know the record. You've got to know where in that record important exhibits are and important bits of testimony. Now again, just like with citations to cases, you don't need to know chapter and verse, page 37, line 20. No, you don't need to know that. That needs to be in your notes if it's a critical point. Because I'll tell you this, and I do this every moot court that I ever sit on as a judge, I will always ask, where in the record is that? When I hear a factual assertion on an important point from one of the lawyers arguing the case. I don't expect the lawyers to have memorized that. In fact, that kind of, as I said, looks annoying. But I expect a lawyer to look down in the brief or in their podium notes and say, Your Honor, that's on page 37, line 2. So know your record. You also have to know the law. Remember, any argument, including an oral argument, has the yin and the yang of facts and law. You can't stand up there and argue all facts. You can't stand up there and argue all law. But when you're talking about law, you've got to know the law. And by the law, I mean the law is set forth in the cases cited in your briefs, in the statutes and constitutional provisions that are all cited in your briefs. You need to know those cases. And again, don't forget basic case info, like the full case name, like the date, like that. Oh, Your Honor, that case is from 1974. And the court, well, that's from the Third Circuit, Your Honor. I understand it's not binding precedent on this court, but so again, you need that basic name, rank, and serial number information about the law. And before your oral argument, you need to update all the authorities to ensure that they still are good law when you stand up there, because there would be nothing more embarrassing than standing up and having one of your principal cases having been overruled days or weeks before. And also, you'd be surprised, you can find good cases that have just come out in the last couple of weeks on a point and say, Your Honor, this is not in my brief, and I'll submit it by letter, by way of a supplemental letter to the court, but then you launch off onto this new case, and everybody perks up when that happens. So do your Westlaw or Lexis research before you go to that oral argument. Okay, final preparation tips. Again, think about how you might connect points back to your core image. And again, we talk a lot about in this class about the importance of a core image. Know it, and then figure out how everything kind of relates back. You're going to end. This argument is going to end. So be ready with a 1-second conclusion. Excuse me, 1-sentence conclusion. You're going to run out of time probably. So practice that. This is something worth practicing. Your Honor, I'm out of time. May I briefly conclude? And the judge is going to say yes. You need to know what that brief conclusion is. Usually it's, for all of these reasons, this court should affirm the district court. Whatever. You need to get a concise 1-sentence conclusion all ready to go so you don't stumble through it. Practice, practice, practice. How do you get to Carnegie Hall? You know the answer. Practice. You all are novices at this. They say you can't get really good at something until you have 10,000 hours of practice. I refuse to believe that, because that would be almost hopeless. But stand up, and I'm standing up here. I'm doing this at a standing desk with a webcam in front of me. Stand up, because that's the way oral arguments are delivered. Even on video camera, you should be standing up, delivering your oral argument. It's much more persuasive than sitting in a chair and swiveling with a big headrest in the back. So stand up. You can practice for oral exercises in this class with your TAs. Just set up an appointment with him or her. You can deliver your oral argument to non-lawyer friends and family, if you're not worried about losing them as friends and family, because it's kind of could bore them, but they may be very supportive and want to hear you. You can't practice, however, with other students or lawyers. And this is one of these honor code things, because this is your exercise. We want you to learn how to do this, not for some lawyer to force feed you or willingly feed you arguments in how to do this. Okay. So you've prepared for your argument. Now you're going up to the podium. What are some thoughts about what you should bring with you to the podium? Well, I've thought long and hard about this, because I've been a lawyer for more than 30 years. I've gone to oral arguments, and by way of my oral argument background, I've probably done at least 50 or 60 appellate arguments over the years before the U.S. Fifth Circuit, probably 30 before the Louisiana Supreme Court, and all sorts of lower court arguments and trial court arguments. And I've gone to the podium with big, thick binders, but I don't do that anymore. And I've become a much more effective arguer, advocate, oral advocate. So what should you bring? Well, The rule for our purposes in this class is one sheet of 8.5 by 11 paper. That's one sheet of paper. That's not legal size paper. That's regular letter size paper with text on only one side of the page. Now, a lot of times in this class, I'll say, let me see your notes. And I'll look and make sure that that's all you've got. You don't have anything written on the back, and you've got text on one side. Now, how could you, what format should this text be? Well, it could be in an outline. It could be just bullet points or key cases or a mind map. I don't care, and your other instructors don't care what the format is, but they do care that it's only one page of notes on one side. And you can just tailor that format to suit whatever you're comfortable with. But don't put too much on your notes. Less is more. You know, I'd like to emphasize it more, but I used huge all caps in red. I don't know how much more to emphasize this other than screaming, and I'm not going to scream into my microphone. I have seen this year in and year out with students. What do? Well, they try to write as much as they can in little tiny print. Sure, it all fits on one side of one piece of paper, but less is more if you just have the main points you're going to make in the order you're going to make them, and the references to the particular pages in the record where you need to direct judges if you get the questions, you're going to do a lot better job. If you have it really small, you tend to spend time going, wait, Your Honor, let me look at this. And you also tend to read. You don't want full sentences on whatever's in front of you. Nope, because you will read full sentences. And we don't want you to stand up and read anything at oral argument. We want you to be looking the judges in the eye, trying to persuade them. Notes that don't conform here, you can't use them. Your instructors are going to take them and say, go. So don't try to get up on that podium with non-conforming notes. Well, here are a few examples. This is what one student used a couple of years back. You know, I thought this was pretty good. It complies with the formatting requirements. It's one page. It also, she's taken her 4 main points and again made 4 quadrants on the piece of paper. She's used different colors. Using different colors is good. And she hasn't written out a lot of sentences. That's a good way to do it. Another way, and this is the way I do it, is with a mind map. Now, this is, again, I don't expect you to be able to read this because this is just a photocopy of a mind map that I used in an oral argument in a case called In Re Seastrunk before the Louisiana Supreme Court several years ago. It was an issue on Brady obligations and a prosecutor's duty to produce exculpatory evidence to the defense in advance of trial. Well, this is all I brought up to the podium. Now, I had another branch that dealt with another issue, but this is what I bring. I highly recommend mind maps for podium notes. I make them very colorful. I put images in them. There are books on mind mapping. Kind of the most basic one is called the Mind Map book by Tony Buzan. You can get it on Amazon. It's B-U-Z-A-N for less than $20. Great introduction to mind mapping. And then there are programs. I use a program called Mind Manager, but there are many others. Mind Note, Mind Meister. Google it. Mind mapping software. You can pay a lot of money for one, like I do for Mind Manager, or you can get one for free. That sometimes you can put the maps on your iPads and take just the iPads up with you. Long way of saying that you need to bring some notes with you that contain just the key points in the order that you want to make them and the detail citations if asked. That's all you want to bring. And you want to make sure that whatever you're standing up there with is not something that is capable of being read to the court. Because what will you do when you get scared? You'll start reading. And no one wants to be read to. So think long and hard about your notes that you're going to bring up. Bring up that one page of notes. Make sure that the text is not too small, and you'll be fine. Okay, well, those are our thoughts on Introduction to Oral Argument. Now, having said all this, the only way to become a persuasive oral arguer is to do oral arguments, is to practice, practice, practice. So that's what you have the opportunity to do in this course. I know it doesn't seem like an opportunity, it seems like a chore. But the only way to learn how to do anything is to do it. And you learn in an area of a kind of personal discomfort. When you stand up, are you going to be uncomfortable? You bet you are. But embrace that opportunity to learn these skills, to practice these skills. And only through that discomfort now can you become comfortable later when some client's life or child custody or financial future is on the line. Good luck.